Hello everybody, Tom here to talk to you about what I think of as the constitutional case of the century, State Ryan against Lennon, decided by the Irish Supreme Court, a three-judge Irish Supreme Court, way back in 1935. It splits that court quite dramatically, 2-1 of course. The dissenting judge, the Chief Justice of the day, Hugh Kennedy, who really pens a particularly dramatic, interesting, dissenting judgment. I don't think I'm alone in thinking of State Ryan and Lennon in these terms. It has generated a great deal of scholarly attention, mainly just in Ireland. Of course, the likes of Professor Aileen Kavanagh, Fergal Davis, Gerard Quinn, Gerard Hogan, Justice Donald O'Donnell, Donald Coffey, several other great scholars and thinkers and practitioners of Irish constitutional law have written interesting articles, book chapters about just this case. And that's only in the last 20-25 years, so of course it has generated a great deal of scholarly attention over the course of the last 80 or so years since it was handed down. State Ryan and Lennon was decided under the Free State Constitution of 1922. In fact, the decision really paved the way. In fact, it was critical, really, to the dismantling of that Free State Constitution. In fact, that's one of the reasons why it is such a dramatic and important judgment, is because it illustrates quite well, I think, not just for an Irish audience, but generally how law has, if you like, the capacity to undo itself. You know, what you saw really here was the dismantling of a constitution by constitutional means. And I suppose another interesting thing about this case is that it's decided in that period, the mid-1930s, when, in quite radically different circumstances, of course, in Germany, the Weimar Constitution is being, or I suppose by that stage, has been dismantled via a tactic of legality of sorts. And there is a certain parallel, but of course we get an utterly different outcome in the sense that ultimately Ireland gets the Bunreacht na hÉireann, you know, the 1937 constitution, which is a good liberal democratic constitution and which remains our constitution today, all 80 or so years later. That's reason enough on its own, I think, as to why this case would have the status that it does, or that I'm suggesting it does. It demonstrates law's capacity to undo itself, constitution to be dismantled by constitutional means, and so on. Related to that, the case is often reflected on in light of the debate between legal positivists on the one hand and natural law theorists on the other. That is to say, the judgments in the majority, as we'll see, tend to be thought of as having, I think, a legal positivist flavour, whereas Kennedy's is very much a natural law oriented judgment. I think probably a better way to think about the contrast between these two positions is legal formalism. That is to say, the judges on the majority very much as it were, complied with the letter of the law, or applied rigidly the strict letter of the law, if you like, whereas Chief Justice Kennedy engages in a form of interpretivism in his dissenting judgment. So that's another interesting thing, I suppose, about this case. The other reason, I suppose, or another reason it's interesting, I suppose, is because it brings to light the puzzles of constitutional democracy very simply, I suppose, and very dramatically. That is to say, do we think of constitutions as ultimately concerned with constraining political actors? Is that what a constitution is for? Political constitutionalists would say not, of course, whether or which. We very much see in this case how, despite the provision, express provision, in this Free State Constitution for so-called judicial supremacy, how the political actors manipulated and exploited loopholes, or manipulated and exploited the levers in the Constitution itself to overcome that, if you like, and dismantle this Constitution. And I suppose it also really shines a light on the puzzles around the judicial role, the judicial power, around how we interpret constitutional provisions, and so on. It's remarkable, perhaps in light of what I've said, how this case actually came about in the first place. It arises from the most obscure and localized row, frankly, that occurs in 1934 in rural, remote County Tipperary, a place called Upperchurch, near Thurles in County Tipperary, on a Saturday evening in August, when 4 men knock on the door of a farmhouse and threaten and ultimately shoot at and injure the farmer, a guy called Edward Canaan. One of the 4 men is Jeremiah Ryan, Jerry Ryan, hence the name of the case, State Ryan, against Lennon. The facts of the case, I don't know if I'll get into them in any great detail, because Ruan McCormack, in his great book, The Supreme Court, published by Penguin in 2016, in his second chapter called Standoff, tells us that story in that farmhouse, gives us that context. It's actually a row about property tax, about rates. And the 4 gentlemen are members of the Blue Shirts, which was an interesting movement, political grouping of that day, of that period. And those 4 men are ultimately brought before a tribunal and are detained in Armour Hill Barracks and challenge the constitutionality of their detention and ultimately of their of the whole prosecution process. And that gives rise to this case, which culminates really in the dismantling of the Free State Constitution. So they're the facts. Really, I think what's probably more important for you to understand the case is the historical context, in that, as I say, this is decided under the terms of the Free State Constitution, which is the constitution that came into being in late 1922, having been drafted by the third Dáil Éireann in the Irish Lower House of Parliament, drafts that constitution. It's a liberal democratic constitution, provides for, habeas corpus, fundamental rights, actually an express provision against retrospective punishment, which is notable because it comes up in State Ryan and Lennon, provision for judicial review, judicial supremacy, separation of powers, etc. But also contains marks of subordination, having come about from the terms of the Anglo-Irish Treaty. Okay, so for example, there's partition, of course, under the terms of the Anglo-Irish Treaty. There is a requirement that members of the Irish Parliament would swear an oath of allegiance to the British Crown, for instance, which is provided for in, I think, Article 18 of that Constitution. The point ultimately is this: that Constitution was never loved by Irish nationalists. It never certainly had their allegiance and was always, in that sense, on death row. And ultimately that death is brought about in some part, in large part probably, because of the judgment of the majority in State Ryan and Lennon. Here is where things get a little bit technical, because we need to understand the design, I suppose, of the amendment provision in Article 50 of the Free State Constitution. That's a tad technical. Also, government ultimately, or governments, successive governments through the 1920s and into early 1930, use that amendment procedure in a kind of a cynical way, you might say, and how they do that is somewhat technical, and that ultimately sets us up then to understand, to access, I suppose, the judgments, which really is what we're interested in. Fitzgibbon's judgment for the majority, Murnaghan's judgment for the majority, and of course the famous dissent, Chief Justice Kennedy's dissent. I think perhaps that's long enough for this video. In the next video, I'll go through some technical features, these technical features I'm talking about. Then finally, perhaps in a third video or perhaps in the end of the second video, I will look at the judgments and explore the broader kind of themes